So hello dear students, welcome to Bajirao Ias Academy interview guidance program. So in today's lecture we are going to discuss about two very important topics. The first topic that we are going to discuss is about Bharatiya Nyaya Sanhita, right? So this Bharatiya Nyaya Sanhita Act is a part, it is, I'm sorry, wait. So recently this Bharatiya Nyaya Sanhita Act is in news. So why? Because the union government has decided to, decided to revamp the existing criminal laws in India. Because most of these criminal laws are either colonial or archaic in nature, outdated and not suited to the current, conditions. So therefore, under Bharat Nyaya Sanhita Act of 2023, the center has brought two different bills, and all these different bills were got the presidential assent. So we will discuss what is exactly the Bharatiya Nyaya Sanhita in this particular lecture, and apart from that we will also discuss another very important article, that is antimicrobial resistance. Okay, so this is also a very important topic. There were instances that UPSC frequently asked questions with respect to antimicrobial resistance. Now we will understand what is this antimicrobial resistance, what are the major causes of it, and how can we prevent the antimicrobial resistance, because the drug resistance among people would make the existing medication or existing drugs ineffective. So therefore, in this context, we will understand what is this antimicrobial resistance and what are the initiatives that were taken at the global level and at the national level to curb the antimicrobial resistance, right? So before the antimicrobial resistance, first take up the Bharatiya Nyaya Sanhita Act of 2023, right? So why it is in use? As I have already told you in the beginning of this lecture, that President has given assent to three criminal law amendment bills. So what are those three criminal law amendment bills? One is Bharatiya Nyaya Sanhita, and second Bharatiya Nagarik Suraksha Sanhita. Okay, so this is Bharatiya Nagarik Suraksha Sanhita and Bharatiya Saksha Adhiniyam. Right, so these are the three criminal law amendment bills that were recently got the presidential assent. So we will discuss them in a detailed way. So before that, what are the basic things that we are dealing with in this particular lecture include what are the significant takeaways from these new acts. Okay, so these three new acts have come up with significant new provisions. So we will understand those significant new takeaways from these three laws. And next, we will also try and understand what are the major changes introduced in this particular act. Okay, so these three criminal law amendment bills have come up with new changes or changes to the existing criminal laws. So we will understand those major changes as well, right? After that, the minor changes that were made in these three acts we'll also discuss. And lastly, we also deal with new offenses that were added under the Bharatiya Nyaya Sanhita. So these are the basic tenets that we are going to discuss in this lecture with respect to Bharatiya Nyaya Sanhita Act of 2023. Now before proceeding, please understand what are those three bills, and these three bills replaced which of the old bills. So first and foremost, you have to understand that the Bharatiya Nyaya Sanhita bill, right? So this is the first bill, the Bharatiya Nyaya Sanhita bill 2023. So this replaces the Indian Penal Code of 1860. So we all know that earlier everything governs as per the Indian Penal Code of 1860. So it essentially contains different punishments for different offenses, right? So similarly, there's a Bharatiya Nagarik Suraksha Sanhita 2023. So it replaces the Criminal Procedure Code of 1973. So this Criminal Procedure Code prescribes different punishments and fines for the people or for the different offenses, criminal offenses especially. And after that, the Bharatiya Saksha Bill, Bharatiya Saksha Bill. So this replaces the Indian Evidence Act of 1972, and these are the three bills which are introduced, right? So these are the three bills which are introduced as part of Bharatiya Nyaya Sanhita Act. Now, in this context, we have to understand the basic objective of introducing such bills. So, what is the objective of introducing such bills? So, the main objective is to overhaul the existing criminal laws. So, because I have already told you that imagine Indian Penal Code was brought to India in 1860 and Indian Evidence Act of 1872. So, they are all very old, archaic and colonial in nature, and they don't represent the contemporary aspects of Indian society, nature of the crime as well. For example, if you look at the crime, it is more organized in nature, and with the growth of technology, the nature of the crime has also been changing, and the nature of crime against children and women is also been changing. So therefore the central government has felt, even the law experts have felt the need for new amendments to the existing laws in India. So accordingly, these three laws were introduced. So they overhaul existing criminal laws and make them more contemporary and comprehensive, right? So the center wanted to make these laws more comprehensive as well and contemporary, in the sense, because whenever they are more comprehensive in nature, they will not give any scope for the confusion with respect to offenses, punishments. Okay, so there will be no legal vacuum exists with respect to certain offenses, and that is also in line with the the contemporary society and the nature of the contemporary society. So this is the basic objective of introducing Bharatiya Nyaya Sanhita Act of 2023. So as part of this Bharatiya Nyaya Sanhita, three bills were referred to the standing committee earlier. Okay, so earlier all these three bills, so which replaces the existing laws, were referred to the standing committee of the parliament, and the standing committee had also proposed key changes to these bills. Okay, so the standing committee actually assesses and scrutinizes different provisions in these three bills, and accordingly it also suggests certain recommendations, and those recommendations were proposed in these bills. So subsequently, Center had revamped the criminal law bills, right? So Center subsequently revamped these criminal laws and introduced these three criminal law bills. So this is the basic essence of criminal law bills or Bharatiya Nyaya Sanhita. Right. So next we will understand certain basic tenets of this particular Bharatiya Nyaya Sanhita. What are the key takeaways from this particular Bharatiya Nyaya Sanhita? So first and foremost, it has added 20 new offenses. Bharatiya Nyaya Sanhita added 20 new offenses because, as I have already told you, that the nature of the crime has been changing. So since nature of the crime has also been changing and the crimes against children and women have been evolving, there were 20 new offenses that were being added into the Bharatiya Nyaya Sanhita. So after that, there were a deletion of certain crimes as well, because 19 provisions that were earlier in existence in the Indian Penal Code, so they were deleted. Okay, so there's also need to delete certain offenses which are outdated in nature, which do not have the relevance in the contemporary society. So therefore they also got deleted, and punishment for the imprisonment was also mandated. So in the sense that the punishment, it has been increased, the punishment for 33 offenses. Okay, so because the society felt that the punishment for certain crimes is not enough, not adequate, so therefore there's a need to increase punishment or imprisonment, and imprisonment has been increased for 33 offenses. These are the basic tenets or key takeaways from the new act. So apart from that, the punishment of fine, so it has also been enhanced for 83 offenses. Okay, so in Indian legal system, in criminal justice system, so there are certain offenses. In those offenses, along with the imprisonment, you would also be laid certain fines. So therefore there are certain offenses, so the government had felt that these fines are not adequate, so therefore 83 new offenses were added, and all the 83 offenses, the fines would be further enhanced, and punishment of community service was also introduced. So in the sense that community service as a punishment would be imposed on a certain individuals. For example, if we talk about attempt to commit suicide, So attempt to commit suicide, there's a community service that has also been mandated along with the 1 year of imprisonment. Okay, so this Bharatiya Nyaya Sanhita had also introduced punishment of community service. So it has been introduced in 6 new offenses. So after that, there is a mandatory minimum punishment provision also that is also being introduced. So it is introduced in 23 offenses. In all 23 offenses, mandatory minimum punishment is necessary. After that, there's a reorganization of existing offenses made wherein similar provisions have been clubbed together. So all these 3 laws, there were different similar provisions. So therefore, in order to avoid the complexity and the confusion and make it further simplify, what this Bharatiya Nyaya Samhita has did that there are similar provisions and all these similar provisions were clubbed together. Okay, so in order to further simplify this, a legal architecture. So these are the key takeaways from the Bharatiya Nyaya Sanhita that were recently passed by the parliament and received presidential assent. Now we will try to understand the major changes or most important changes so that were actually made in this new act. Okay, so certain important changes were made in this new act. So first and foremost, it had changed the definitions of child as well as the beggary. Okay, so child and beggary are very sensitive issues. So because they involve people who are most vulnerable. So therefore, in order to prevent the exploitation of the people in the name of child and beggary, so the definition of child and beggary have been changed, because children are being used for human trafficking, and even beggary is a reason that further propel human trafficking and exploitation. So therefore, stricter provisions, we can expect that more strict provisions in the Bharatiya Nyaya Samhita with respect to child and their exploitation for illegal causes. And after that, there's a modifications that were also made for certain property, that is movable property. So property that is movable in nature. So the definition of movable property under the Bharatiya Nyaya Sanhita had further widened. Okay, so therefore this could include property of every description. Now with respect to movable property, when the definition is widened, then it prevents the money laundering or even evading the taxes or tax evasion on that. So it will cover the wider property, and that could also significantly increases the tax revenues of the government, and it will also prevent crime or civil disputes which are associated with this movable property of the people, right? So in a definition of a grievous hurt, so there's a definition, there's a grievous hurt also. Okay, so hurting someone, so that is grievous hurt. So with respect to the grievous hurt, the number of days has been reduced from 20 days to 15 days. So in the sense that when I say grievous hurt, for example, one particular individual was grievously hurt, so in order to investigate the matter or in order to provide justice, so that number of days are being reduced from 20 days to 15 days. So this will also significantly benefit the people who have faced this problem, or who have faced the menace of grievous hurt to them, physically, mentally, sexually. Okay, so after that, there's a new chapter that is also being introduced as part of Bharatiya Nyaya Sanhita. So what is this new chapter? So this is particularly deals with the women and children. So again, women and children are vulnerable categories. So they belong to vulnerable categories. So therefore, Bharatiya Nyaya Sanhita ensures that the strict provisions are in place in order to prevent the exploitation, exploitation of women and children. So on inchoate offenses. Okay, so on offenses against women and child and inchoate offenses, there was a new chapter that is being introduced in the Bharatiya Nyaya Sanhita Act. Now what are these inchoate offenses? So inchoate offenses in the sense that those offenses which are not fully committed, rather there was an attempt that was being made to commit such offenses against child or woman. So they are considered as inchoate offenses. So with respect to inchoate offenses also, Bharatiya Nyaya Sanhita had introduced a new chapter. And after that, sedition, this is also a very important. So sedition under the new name called Deshdroh, so it had a wider definition. Okay, so sedition was also introduced in the Bharatiya Nyaya Sanhita in the name of Deshdroh. So it covers acts of subversive activities and those encouraging feelings of separatist activities. For example, Khalistani activity. Okay, Khalistani activity can be branded as Deshdroh activity. Okay, so several subversive activities and separatist activities can be branded as Deshdroh or sedition activities. So earlier sedition used to govern by the IPC section 124. Yeah. Okay, so IPC section 124. Yeah. Okay, so now sedition is branded as a Deshdroh in Bharatiya Nyaya Sanhita Act. So after that, there were different attempts that were being made by Bharatiya Nyaya Sanhita to bring gender neutrality into this. So what does this gender neutrality exactly means? Gender neutrality essentially means laws which are applicable equally to both males as well as females, right? So any law which is gender neutral in the sense that the law is applicable equally for both males and females. Okay, so while rape laws are actually operate only in favor of women, okay, so in the sense that the rape laws are biased in favor of women, and some children related laws were modified. So for the offenses which have been dealing with the kidnapping of minors, it is 18 years for both the genders, right? And for adults, the offenses of outraging the modesty of women, so this is mentioned in section 354A of the IPC, and voyeurism, so 354C, so now has a gender neutrality for the accused. So gender neutrality for the accused in the sense that, so whoever commits this offenses, the criminal offenses such as outraging the modesty of woman or committing voyeurism. So voyeurism in the sense that getting a sexual pleasure through watching some something like a sexual activity, so that is considered as a voyeurism. So modesty of woman or voyeurism under section 354C have a gender neutrality for the accused, so which means that women can also be booked. So as I have already explained you, what is gender neutrality? Gender neutrality is that, so both men and women can be booked under a particular law, or laws can be applicable for both men and women equally. So therefore under these three sections, IPC section 354A and voyeurism section 354C would have the clause of gender neutrality. And after that there is an attempt to suicide. So this is also being criminalized by the government. So criminalized in the sense that, so there would be punishment for attempting suicide under this Bharatiya Nyaya Sanhita Act. So it criminalizes the suicide attempts with an intent to compel or restrain any public servant from discharging his official duty. Now generally what happens that there were a few people who attempt to commit suicide to compel the government or public servants to do their particular work. Okay, so because of this reason it criminalizes the suicide attempts. Imagine that you have some work with the district magistrate, and district magistrate due to various reasons asked to come to the office very often, or your work is not done by the DM. So you start threatening him with the attempt to suicide. So this is what is being criminalized by the government, because it has been obstructing discharge of the official duty of any officer. So attempt to suicide has a jail term which may extend up to 1 year, and it would also have the community service. So community service in the sense that serving old or serving any particular class or something like that. No, class in the sense that serving in a old age homes or something like that is considered as a community service. So it could be invoked to prevent self-immolations and hunger strikes during the protests also. So for example, during protests someone starts the self-immolation and even hunger strikes. So however, this attempt to suicide provisions would also be used to prevent self-immolations and hunger strikes as well. And so after that, damage to property, damage to public property. So that was also for example, if you look at the CAA protests, Citizenship Amendment Act protests in UP, there was a damage to the public property, and accordingly the government had also charged individuals with this damage to the public property. However, this Bharatiya Nyaya Sanhita had certain provisions with respect to damage to the public property. Now it is now considered as a graded fine. So graded fine in the sense that, for example, imagine an individual, he had caused damage to a public property worth of 1 lakh rupees, worth of 1 lakh rupees. And imagine another individual, he committed the damage to the public property worth of 1 crore rupees. Okay, so there would be a graded fine, which means fine is based on the amount of damage that is being caused to the public property. So both of these individuals have caused damage to the public property. So however, individual A would attract a lesser fine and individual B would attract greater fine, because the damage that is being caused by both the individuals is different. And after that, India as a country had seen mob lynching and hate crimes and murders as well previously. So therefore, Bharatiya Nyaya Sanhita had a specific provisions, introduced specific provisions with respect to mob lynching and hate crimes or hate murders as well. So in cases of mob lynching, where it involves mob lynching of 5 or more individuals, commits a murder based on race, caste, community and personal belief. So the punishment for such mob lynching extends from life imprisonment to death, right? So it also makes sure such mob lynching would attract the imprisonment of life imprisonment, or even would be death penalty for such crimes. And after that, the nature of the organized crime or the nature of the crime has been changing, and organized crime has been increasing manifold in countries like India. So therefore, organized crime also have certain provisions in this Bharatiya Nyaya Sanhita. So this particular Bharatiya Nyaya Sanhita had prescribed vast powers of surveillance, and it also talk about relaxation of standards of evidence and procedure in favor of the state. Okay, so whenever there's an organized crime, so what happens? So that significantly gives a lot of powers, surveillance powers to the state, and it also relax standards of evidence and procedure in favor of the state. Okay, so this is what the organized crime related provisions in the Bharatiya Nyaya Sanhita Act. So after that, the punishment had also been prescribed for the organized crime. So attempt to commit and committing is considered as same. For example, imagine an individual who is attempted to commit an organized crime. So organized crime is human trafficking is considered as an organized crime, and apart from human trafficking, drug trafficking is also considered as a organized crime. So even any individual who is attempted to commit a crime or committing the same is considered as a crime under this Bharatiya Nyaya Sanhita Act. So but the distinction is based on whether death is caused or not by alleged offenses. So only distinction is whether death is caused or not caused by this alleged organized crime. So these are some of the provisions that were being introduced as part of the Bharatiya Nyaya Sanhita Act, and certain new offenses that were also introduced under this Bharatiya Nyaya Sanhita. So they include organized crime and petty organized crime. So petty organized crime, the nature of the crime is little lower compared to the organized crime. So after that, the mob lynching also. So earlier there were no exact or clear provisions for mob lynching. Now Bharatiya Nyaya Sanhita had introduced provisions for mob lynching as well. And terrorist acts, hit and run cases, hiring child to commit offenses. Now child is being hired to commit offenses because the legal loopholes which are in existence, because child is considered as a juvenile and he can easily escape the legal provisions. So therefore, hiring a child to commit an offense, snatching and abatement outside India, and acts which are endangering the sovereignty, integrity and unity of India, and publication of false and fake news is also being made part of a offense under the Bharatiya Nyaya Sanhita Act. So all these were new offenses that were being introduced in the Bharatiya Nyaya Sanhita Act. So however, the attempt the effort of the government to introduce Bharatiya Nyaya Sanhita to revamp the existing criminal laws is laudable, because as I have already told you that they are archaic in nature and they are colonial in nature and they are not suitable for the contemporary society or current conditions. So therefore, revamping the current Bharatiya Nyaya Sanhita is a welcome step. However, certain provisions which are objectionable need a relook. Okay, so that's all about Bharatiya Nyaya Sanhita, and thank you. So if you really like our work, please subscribe to our YouTube channel and also hit the like button. Thank you.